Hey everyone, welcome back. As you'll recognize, the last few lectures have been on various components of the federal government, starting with Congress, then moving on to the executive, and then the bureaucracy. We're going to close out this section of the course today with the last section of government. We're going to talk about the federal judiciary. So what is the judiciary? We've talked about it at various points in time so far in the course, just because talking about concepts like judicial review, enforcement, dispute resolution, things like this came up as important topics. So the federal judiciary is a part of the government composed of various courts. Here's cases concerning federal law, interpreting whether parts of the law conflict with the Constitution, determining when federal law has been violated, and also sometimes adjudicating disputes between individuals, companies, or actors within the private sector. So, when we talk about the court system, getting into its various functions, we'll talk about this more in a second, but it's important to realize that a lot of these things that we're talking about deeply intertwine the courts with really important areas of policy. So court decisions affect things like speech, civil rights, civil liberties. We talked extensively about court cases that were relevant to things like free speech, religion, the press, back when we had our lecture on civil liberties. Healthcare is another big area of policy that the court has influenced recently. So it's not really just hearing cases and ruling on them. These rulings have really big policy implications, and the courts can affect policy just as much as Congress or the president can. All right, so getting into what we're going to discuss specifically in this lecture, we're going to first talk about some broad principles that define the legal system. We're going to talk about what the Constitution says about the judiciary, how it's outlined there, and what isn't outlined there. We'll then get on to talk about how the court is structured today, and its hierarchical structure and the various components of it. We'll then talk about the appointment process. We've mentioned at a few points earlier that appointments to the federal judiciary are handled by the president and the Senate in concert with one another. We'll talk in more detail about this process. Then finally, we can talk briefly about those who are sitting in the federal judiciary at any of the levels. How do they go about making their rulings? There are various different theoretical models that could characterize how these judges behave in the judiciary, and we'll go over three of them in particular. Alright, so to begin, let's talk in broad terms about the types of principles that define our legal system. The first being that we have an adversarial system in the United States of America. So what this means is, most of you have probably heard terms like plaintiff and defendant. So in any given case, you have someone who's bringing the suit or the case, the plaintiff, the person who's defending against whatever charge is being brought or accusation, the defendant. And the way this works in the United States is, in the course of a trial, the plaintiff brings their case. They talk about what they think the facts are, what the relevant legal principles are, the laws, maybe sometimes portions of the Constitution, and then the defendant will go up and do something similar. If they are disputing the facts in the case, they'll go up and do that. If they have an alternative interpretation of the law or relevant legal principle, they'll go up and talk about that as well. So basically, in an adversarial system, you have the two sides going up against one another in court. The major investigatory and analytic work is done by the plaintiff and the defendant to make their case. This stands in contrast to a system that was found more so in past, but sometimes elsewhere in the current era in some places, the inquisitorial system, where the judge who's presiding over the case is really in charge of investigating and establishing the facts and the relevant legal principles. So in an inquisitorial system, the judge would be up there asking the defense and the plaintiffs, what happened, what sort of laws do you think are relevant here? And the judge will really have a driving role in moving the case forward and uncovering facts. In the system we have, it's up to the plaintiff and the defendant to make their own case and present the facts on their own. Okay, so another thing to recognize is the two types of cases that are dealt with in the federal judiciary and even in state courts. They can be characterized in this broad way. So when we talk about two different types of cases, the first being criminal cases, and this is maybe what we think of more commonly when we think of courts and the legal system. This would be cases involving violations of the law. So the federal government passes a law, it goes through Congress and then gets signed into law by the president. It says that something is prohibited. If somebody does this thing and violates the law, this is what criminal cases cover. In this case, the plaintiff would be the government itself. The defendant would be the person being accused of violating the law. So just know, when we're talking criminal cases, these are violations of things that are specifically written down in the law that people aren't allowed to do. Typically dealing with safety, order, violence. We can think of any number of examples of things that are against the law. These would all fall under criminal law and criminal cases. On the other hand, civil cases are a bit different in that they don't usually involve a specific violation of the law, though sometimes portions of the civil code are written in nature and in a statute. Civil cases are dealing with private actors typically, where one has been allegedly damaged by the other. So if somebody does something to harm someone, you can bring the person that's been harmed can bring a suit as a plaintiff against the person who committed whatever action we're talking about, who would be the defendant. So you think about if you have a workplace negligence incident, the plaintiff in this case would be the worker, the defendant, the employer who did whatever to cause an injury, perhaps to the employee. Sometimes civil cases also involve a suit from an individual or business or private actor against government itself. So if somebody thinks that a policy passed by government is against the Constitution, for example, or it's being applied in a way that's inconsistent with the law, you have the right to sue in courts to have your case heard, and sometimes the courts will rule that the government is just doing something wrong. In terms of the cases that can be brought forward and heard in our legal system, there are a couple of criteria to be aware of. Most important being standing. This is often a big issue in terms of who can bring a suit forward. So standing means that in order to bring a suit forward, in other words, in order to have standing to validly file suit against someone, you have to have some sort of well-defined injury or violation of the civil code. So if you're not the one being harmed, you can't bring the case forward. If your brother slips and falls at the restaurant because of they didn't properly mark a leak or something, and the floor is too slippery, you can't sue on behalf of the person that was actually injured. It has to be you suffering an injury in order for you to bring forward the court case. And so this will often come into play, usually not in really easily defined cases like the one I just outlined as the example, but when there are more abstract instances of laws that people disagree with in either their substance or interpretation, sometimes it can be an issue determining whether they actually have suffered any sort of well-defined injury to justify bringing the suit, which is aimed at maybe repealing or changing the way a law is enforced. Another requirement to bring suit is this principle called ripeness, meaning that you can only bring a suit where the harm has actually already taken place. You can imagine maybe you think the application of a law that's been passed and maybe hasn't been put into effect yet might harm you down the line, but you're not actually allowed to file suit until some action has actually been taken place or some violation or harm suffered. You can't preemptively sue, in other words. All right. Let's talk now about the U.S. Constitution and what it says about the judiciary. We talk about the Constitution in pretty much every lecture for good reason. So going back to the congressional lecture, Article 1 is dealing with Congress. Article 2 deals with the presidency. As you might predict, the judiciary is discussed in Article 3. The Constitution outlines some roles for the judiciary that we've discussed already. Is there to interpret laws? It's there to make sure that they're being enacted appropriately and not misapplied. They're there to sometimes make judgments where there isn't any legislation, if there's some ambiguity and some gaps between the laws. They're there oftentimes to make sure the laws are enforced appropriately and dole out punishments to people who violate them, or in the course of a civil case, provide compensation to cases where people have suffered some injury from either government or someone else. So these are all roles that we've talked about a bit so far. This is pretty much how the Constitution envisions the court system operating. What's interesting about Article 3, though, is that there aren't too many specifics as far as what the court's actually going to look like. It says there's going to be a Supreme Court, and it outlines certain areas of jurisdiction that's going to have where it hears these cases, as opposed to some other lower court, but it doesn't outline what the actual lower portions of the court is going to look like. So when we get into talking about the structure of the courts, which we will hear in a second, the way it's structured today is as a result of congressional legislation. It's not actually outlined in the Constitution that it has to look in a certain way. We've just arrived at the way it does now because that's the way Congress, working with the president, has decided it should be arranged. One other thing to note in terms of what the mandate is for the courts written in the Constitution, we've talked about judicial review in the past. For example, extensively in the Civil Liberties lecture. Note that this isn't a power that's outlined specifically in the Constitution. This is something we've talked about before in the context of the Constitution in that lecture. But it's worth reiterating here when we're talking about Article 3. There's nowhere in Article 3 does it say that the court system have the right to declare things unconstitutional or constitutional. It didn't have that sort of major role built in. This is something that's assumed by the Supreme Court later on in the case Marbury versus Madison, which is one that you all should be aware of and know so far. All right, moving on though, it's also important to recognize that the courts, they make rulings, but you've probably realized by now, given what we've already talked about, the way the rest of the government functions, that they don't actually have the power to enforce them on their own. So the court can say something's illegal and something has to change as a result, but generally the actual force and the practical mechanisms to put rulings into effect, that's going to be found in the executive branch and sometimes a department or a law enforcement agency of the federal government. So the court is there to make decisions, basically, but it relies on other parts of the government to enforce them and put them into effect. The important thing about this is that because the court doesn't have this executive power on its own, it has to foster legitimacy. So in other words, it has to have other parts of the government and the public at large think that it's acting in an appropriate manner. The public and all the different parts of government don't have to agree with the court in all cases, but overall, there has to be a degree of respect fostered there. It can't be the case that the court keeps doing things that are recognized as illegitimate over and over and over again, and they're seen as overstepping their bounds, or else you may get to the point eventually that the executive branch starts enforcing the court's decisions more selectively, or perhaps not at all. So, maintaining this respect and legitimacy is really important when we're talking about the judiciary. In terms of public support, this is obviously a big component of the court's legitimacy. If you want to speak about this, the courts have basically been pretty successful throughout history in maintaining a degree of respect among the public. For example, this is the most recent polling data that I found on this question, dating back to February of 2016. How do you think the Supreme Court is in doing its job? Only about 15% say poor. The rest, for the most part, fall within fair, good, or excellent. A few people down here aren't sure, but overall, there aren't a large number of people in the population that are super dissatisfied with what the court is doing. Alright, the next topic that we're going to talk about is how is the judiciary actually structured? We talked about what it does. Now let's talk about what it actually looks like. Alright, so first of all, let's distinguish what sort of cases the federal judiciary actually hears. This lecture is aimed specifically talking about the federal government's judiciary, but the state of New York, every other state has its own judicial bodies, municipalities and counties as well. These lower, the lower tier bodies in the states and the localities, this is where most of the cases in the country are heard. Like when most criminal cases, if you do something against the law, it's typically covered under state law rather than federal law. Most civil cases, one person bringing a case against another person, it's only really some specific circumstances that would lead a case like that to land in federal courts. So what kind of courts does the federal judiciary hear? So obviously, first of all, those in which the federal government is a party. So if there's a federal law on the books and someone thinks it's being misapplied, they can sue the federal government or petition the courts for whatever they want to happen as far as that law, either being repealed or parts of it being applied differently. Anything that's involving the U.S. Constitution, federal law, international treaty, again, obviously this is, if you have a question of the U.S. Constitution, it's not going to be heard in a state court. In terms of federal law, like I said, most criminal law cases are dealt with at the state level. However, obviously there's a pretty extensive criminal code dealing with the federal government as well, and if you violate federal law, your case is going to be heard in federal court. Anything dealing with an international treaty, by definition, the federal government is the only body allowed to make treaties and, in general, deal with foreign governments and establish foreign policy. So this is, again, something that's going to be heard in the federal courts as opposed to the state courts. In another special case, if you have two individuals that are living in different states and are involved in a civil suit with one another, a lot of the times it'll be held in one state or the other, but if it rises to a certain level in terms of significance or the monetary impact, it can sometimes be heard in federal cases as well. Now getting into a discussion of, given that there are certain types of cases that fall under the purview of the federal judiciary, how is it structured to hear these cases? The defining feature of the federal judiciary is its hierarchical structure. So most cases flow from a lower court level, up to higher levels of appellate courts. We're going to be talking about three specific core parts of the judiciary. The lowest level courts, known as the district courts, the appeals courts, which hear appeals emanating from the district courts, and then finally the highest level of the courts, the Supreme Court, which is a body we've talked about extensively already. We'll talk about it a bit more today. To give you a sense of how these various rungs in the hierarchy compare to one another, in terms of size, we have 94 district courts. So typically each district is going to be confined within a particular state. There are about 700 district court judges throughout the country. In contrast, there are a lot fewer circuit courts of appeal, which is the next level up, the immediate level of appeal, where appellate cases are heard coming from district courts. So usually, really in all cases, the district courts, the appellate courts of appeal are going to be covering multiple different states. So there are very few of them in the country, and a lot fewer judges. It's composed of only about 170 judges in the circuit courts. The Supreme Court, as we know, there's only one Supreme Court. It's usually comprised of 9 justices, though at the current moment there have been only 8 for the last almost year now. All right, to begin though, let's go through the appellate structure of the court. So where do the cases begin and how they work their way up through the various levels of appeal. So almost every court case in the federal judiciary begins at the district level. There are very few that start out at the Supreme Court. So the Supreme Court has original jurisdiction over a very small few different types of cases, but almost all cases originate at the district court level. So if you have a criminal case that's being heard, it's going to start here. If a civil case, the vast majority of them are starting here. So what happens here is the plaintiff gives their arguments, the defendant gives their arguments, and the judge presiding, if in a civil case, will make a ruling. Or if it's a jury trial, the jury makes its ruling. If it's a criminal trial, there will always be a jury making a ruling. But ultimately, whoever loses, the important part here is that they have an automatic right to appeal to the next level up from the district courts. We'll get to that in a second, but to just illustrate the sort of the geographic confines of how district courts are usually presiding over a specific area, where we are, or at least where the university is. If you're watching this from somewhere else, then maybe you're in a different jurisdiction, but where the university is, we're subject to the district court for the Eastern District of New York. So you see it covers only Long Island, Queens, Brooklyn, and Staten Island. The rest of New York would be subject to various other types of districts. So this is a pretty small geographic location. If you end up, for whatever reason, needing to go into the federal court system, hopefully this isn't ever the case, but if you're here, this is the courthouse in Islip. So right here, there's another one in Brooklyn. So these are the district court. This is where those cases are heard. So most cases, some of them go on, but most of them at the district level terminate at that level. A lot of them through pretrial settlements between either the plaintiff or the plaintiff and the defendant, or the prosecutor and the defendant. So a lot of them will be settled that way. A lot of them will just be ruled upon, and then the person who loses has no desire to appeal to a higher level. However, those people who do lose at the district level that wish to go on, they think they've been treated unfairly or the ruling is incorrect, they can appeal automatically to the circuit courts of appeal. So what happens here is usually a panel, usually of like 3 judges at the circuit courts. They'll review the facts of the case, the legal elements of it, to see whether things have been applied or not. Most often, it's not the appellate court's job to relitigate the facts of things. Most often, they're just looking to see whether the correct case law has been applied, whether the correct precedent has been applied, whether there's anything, their interpretation of the relevant laws or portions of the Constitution have been applied correctly. So really just a legalistic review, typically, at the circuit court level. And typically it's done by a 3-judge panel. Sometimes a defendant can petition for the entire court to hear a particular case. But eventually they'll have a ruling that comes out of the circuit court level, and then at that point you have another loser. Sometimes it's the same person who lost at the district level. Sometimes it's there's a reversal. But ultimately, whoever loses at the circuit court level has one level of appeal left that they can attempt, that being the Supreme Court. And we can talk about that in a second. Let's take another look, though, at some geographic context. You see here that the geographic confines of these circuit courts of appeal are actually quite extensive. So, getting back to where we are, we're in the 2nd district, and the appellate court covers 3 separate states. So, New York, Vermont, and Connecticut, whereas the district court is only this tiny bit of New York here on Long Island. If you ever, to continue on with your case, your hypothetical case, if you ever end up in the federal court system and you lose over at the Islip courthouse and you want to appeal, this is where you'd go for your appeal. This is the Thurgood Marshall building in Manhattan, which houses the United States Court of Appeals for the 2nd Circuit, which is where we fall in our jurisdiction. Alright, so getting back to moving up the hierarchy, when you lose at the appellate level, you do have one last option to try to appeal, and that's to the Supreme Court. So when this is the case, you'd put together a written document saying why the court should hear your appeal. However, whereas you have an automatic appeal from the district level to the circuit court level, the Supreme Court gets to decide which cases it will hear. And as it turns out, it's actually quite choosy. The most it's ever heard in a particular year is 92. So about less than 1% of the cases, right around that mark, 1% get heard by the court. So the vast majority of them, the court says, no, we don't really have any desire to hear this appeal. When that's the case, when the Supreme Court says we're not going to hear the case, whatever the appellate court ruled, that basically stands. So speaking in terms of what the Supreme Court will like to hear from, in that 1% of cases that it chooses to hear, there's going to be things where either there's the Supreme Court sees a really egregious misinterpretation of the law, or there's a high degree of ambiguity in terms of the relevant laws or portions of the Constitution that are or precedents that are relevant to the case, or when there's a really high amount of impact in this case on the way that the Constitution is applied or interpreted. Things like this that are really significant, or cases where they just think the lower level courts maybe have misinterpreted or misapplied the law. These are the types of cases that the Supreme Court will want to hear. So the way they go about it, the actual process of deciding, is that the judges get together and they read the petitions for certiorari to the Supreme Court, and it only requires 4 justices actually. It's known as a rule of 4 to accept a case and bring it to the Supreme Court. So that's an interesting facet. You don't even need a majority to bring it to the court. You only need 4, but still they're quite choosy as far as what they want to hear. In the rare event that the Supreme Court comes across a case that it wants to hear, it issues what's known as a writ of certiorari. This is just the formal recognition that the court is going to take a case from the appellate level and hear it itself. Speaking now in terms of what goes on at the highest level of the hierarchy in the Supreme Court, the proceedings are actually pretty uniform and scripted. So once they decide to hear the case, what happens is the defendants and the plaintiffs will both submit legal briefs. These are just the written out arguments. So if you're someone who's lost at the lower level, again, you'll be writing about why you think the legal interpretation of the appellate court is incorrect. If you're the defendant, you'll be writing, the plaintiff, you'll be the person who won, I'm sorry. You'll be writing about why you think the lower court rulings were correct. So this is really the most important factor in the ultimate decision of the court. What the legal arguments are here, what the relevant case law, constitutional provisions, and precedent are. Worth noting that when cases come to the Supreme Court, you don't necessarily have to be an immediate party to them to have an influence. Sometimes the court will read and respond to what's known as amicus curiae briefs. These are briefs submitted by interested parties that aren't directly tied to the case. So in other words, they're not a defendant or a plaintiff. If there's a case coming across the court that you think might impact your industry or you personally, you can submit a brief saying whatever your legal reasoning is for why the court should rule in a particular way. Oftentimes the federal government itself will, when it's not a direct party to a case, but something about the case has implications for the application of law, the executive branch, usually through the Solicitor General, can submit amicus curiae briefs on behalf of the government and say, this is the impact that one particular ruling or another might have on how we go about our business, and this is how we think the ruling should go. Oftentimes, the amicus curiae briefs aren't really that important in the case. On a few rare occasions, they can be given significant consideration, though, by justices on the court. After the briefs are submitted and gone over, there are oral arguments allowed. Each side gets about half an hour to go up and discuss its reasoning for why it should win. During this period, sometimes justices will ask questions to either the plaintiff or the defendants if they have any particular things that they want clarified by them. Again, though, I think most people would say that it's the briefs and the reasoning provided by the justices themselves that has more of an effect rather than the oral arguments. When we think of like criminal trials, the lawyers going up and questioning people who are testifying, things like this, we think of those as important, and they are. But once you get to the level of the Supreme Court, the facts have already pretty well been established in most cases, and it's really just the legal reasoning at that point that matters. So oral arguments are really the conclusion of the role for the plaintiffs and defendants in the case. After that, the judges meet in a conference, begin talking about what their thoughts are on how they might want to rule. Once you get a sense of what the ruling is going to be, usually through preliminary decisions, the justices all indicate how they think they're going to vote on the case in favor of either the defendant or the plaintiff. At this point, it's the role of the Chief Justice to decide who actually writes the decision for the case. The decision being what the actual ruling is, and what are the relevant implications for law. Usually, what we're most concerned with is the majority opinion. This being, whatever side has the most votes on the court, either the ruling in favor of the defendant or the plaintiff. The majority is 5 out of 4. Sometimes you get higher degrees of consensus on the court. But whatever side is in the majority, they decide. The Chief Justice decide who writes the majority opinion, and this is the official decision of the court as far as whether the plaintiff or the defendant wins. And it's also outlining the legal reasoning used by the majority side in this case. Oftentimes, what's written in these decisions will have a lot of really large influence going forward on precedent in future cases similar to the one in question, the application of law, the interpretation of the Constitution. So the majority opinion is really important, and so this is really the most important distinguishing role of the Chief Justice as opposed to the Associate Justices, in that the Chief Justice is in charge of deciding who writes this opinion. Another type of opinion you'll want to be aware of is a concurring opinion. These are sometimes written by people who agree with the overall choice of the majority. So if the majority voted, let's say 6-3 in favor of the plaintiff, and you're a justice who also agrees that the plaintiff should win, however, you maybe have some other type of reasoning that's different from what's presented in the majority opinion, or you just want to add some additional logic to it, you can write what's known as a concurring opinion. So you're voting with the majority, you're just presenting some additional written argument as far as why you thought the ruling should be the way you did. Finally, the dissenting opinion, as you would probably guess, this is another opinion that happens to be written by the side of the court. If there are any justices who are voting in dissent to the majority, why they think the majority is wrong. If the majority is voting in favor of the defendant, for example, the dissent would be written by a justice or a set of justices who didn't agree with that and think the plaintiff should win, and outlining why they think the majority is wrong, why they thought the plaintiff should have won. So dissenting opinions aren't binding on anything. It's the majority opinion that really matters as far as establishing precedent and the application of law going forward. Dissenting opinions sometimes can have impact as far as legal or ideological thinking going forward. Sometimes it can inform the way justices think about cases in the future. Again, though, it's not legally binding. That's only the majority opinion. Alright, so now that we have talked about what the court looks like, what its structure looks like, let's talk now about how the court is actually comprised, the individuals within it, and how do they get those positions. All right, we've talked in previous lectures specifically in terms of Congress and the president about how appointments are made in the executive branch. Appointments into the judicial branch follow a very similar path. So the president, whenever there's a vacancy in the district, appellate, or Supreme Court, he makes a nomination, decides who he wants to fill it, and then that person goes on and receives either Senate approval, in which case they take their position, or they're denied Senate approval, in which case the president has to come up with another nominee. What's really different from what really distinguishes these judicial nominees from executive branch nominees is that executive branch officials generally serve at the pleasure of the president, and whenever a new president comes in, they're replaced by whoever the new president wishes. However, judicial nominees serve lifetime terms, so once they're conferred by the Senate, they are there for however long they want until they either retire or pass away. So this has a really long-lasting impact on the course of government. So these have the potential to be a lot more contentious appointments than executive branch appointments. And let's talk now about first the confirmation processes at the district and appellate levels, and then we'll move on to the confirmation process at the Supreme Court level. So at the district level, there's not always a ton of contention regarding these nominees. As compared to appellate court nominees, and especially Supreme Court nominees, these receive a lot less scrutiny and are generally a lot less controversial. In large part, this is due to the way that the president selects them. So when the president has a district court judge position that he needs to fill, he does so in consultation, typically with the senior senator from the state that houses the district where the vacancy is. So if someone in the New York Eastern District, they decide that they want to retire, Chuck Schumer is the senior senator for the state of New York. The president would consult with him, and he would generally put a name up, see what does Chuck Schumer think of him or her. If Chuck Schumer likes the nominee, they'll go forward with it. If he doesn't, then he'll try to figure out what a more favorable choice would be. So in this sense, district court nominees, they typically are made with a higher degree of consensus when they get sent in to eventually be confirmed or denied by the Senate. When we move up to the next level in the judicial hierarchy, though, the appellate level, the circuit courts of appeal, this is where the process can start to get really contentious. So first of all, senatorial courtesy is not generally observed for these choices. The president usually makes his choice in consultation with just whoever his close advisors are and maybe some of his co-partisans in the Senate, but he's not going specifically to senators from the states that are within the jurisdiction of whatever appeals court has an opening and asking them what their opinion is going to be. In addition to this, the Circuit Court of Appeals generally have a higher degree of long-term influence through their case rulings on law and the interpretation of the Constitution than district court rulings do. So any case that's going to the district court that's really important to applications of the law and Constitution, like I'm saying, and it has far-reaching consequences that could go into the future. It's generally going to be appealed up to the appellate court level, right? So we talked about how the district courts, the loser has an automatic right to an appeal if they wish. So the appellate court is really where you start getting these consequential rulings. So in this respect, the nominations for the circuit courts of appeal are a lot more important than those for the district courts. And this is reflected, for the most part, in terms of the patterns of district court nominees that are confirmed compared to circuit court nominees that are confirmed. So here, the various bars correspond to different Congresses going back through time. This is the most recent one on this chart is the 108th Congress, which is kind of out of date at this point, but still, this illustrates what we're talking about pretty well. And then on the y-axis is the percentage confirmed of either district court nominees in green or circuit court nominees in orange. For the most part, the district court nominees always are approved at a pretty high rate. Oftentimes, though, you'll see the circuit courts not so much. Specifically, when we get into these latter Congresses, 108th, 107th, 106, where you really start to see these circuit court nominees fail to be confirmed at really high rates. This time period corresponds with the beginning of the George W. Bush administration. So in his first term, he's dealing with, at least for the first few years, a Democratic-led Senate who really isn't sympathetic to a lot of his appellate court nominees, so they get blocked in the Senate. Even in later years in his term where the Republicans gain control of the Senate majority, they don't have a filibuster-proof majority, so Democrats are still able to block a lot of these circuit court nominees. If this chart were to go forward in time through the subsequent Congresses here that are working with Barack Obama, you would also see that a lot of his nominees have trouble going through to the circuit courts as Republicans begin to filibuster them. In fact, we've talked about this before, when you get to the 113th Congress, the Republicans are still holding up a lot of Barack Obama's nominees to the circuit courts and other positions. And so in the 113th Congress, which at that point, the Democrats are still in charge of the Senate, led by Harry Reid, they decide that they're going to do away with the filibuster for all presidential appointments besides the Supreme Court. So, in other words, these appellate positions, they can no longer be filibustered, so it's a lot easier for the president to get them approved at that point. And that allows, when that happens, Barack Obama's nominees to go through for the most part. Then going forward, it's going to allow most of the, unless for some reason the Republicans decide to undo this measure, which they probably won't, it'll allow most of incoming President Trump's nominees to go through without too much of a challenge as well for the duration that the Republicans are allowed to maintain control of the Senate. Moving forward, we haven't talked anything about Supreme Court appointments yet. These are even more important than these appellate nominations, of course. The Supreme Court is comprised of only 9 justices, and this is where the most important and the most far-reaching cases are heard. So, for obvious reasons, this is the most important appointment that a president can ever make. Again, these are people that are going to serve lifetime appointments on the Supreme Court unless they decide to retire. They're hearing really important cases, and so these nominations can become really, really politically charged. When there is a vacancy in the Supreme Court, the president will make his nomination, and then that nominee will first go on to the Judiciary Committee in the Senate. This is a standing committee within the Senate that, among other things, holds hearings to whenever there's a Supreme Court nomination to determine whether or not this person is well qualified. So they'll ask things to try to get at the person's judicial expertise, what their legal philosophies are, and then eventually, after these hearings, the Judiciary Committee gets to vote on the nominee, and if they approve of the nominee, he leaves the committee and then goes on for a vote in front of the full Senate. Getting back to the discussion of the filibuster, these nominees still are subject to filibuster, so the measures taken in the 113 Congress didn't affect filibusters for the Supreme Court. However, you can imagine a situation going forward where if, because there's been already a weakening of the filibuster precedent, if it does ever come up to a filibuster of a Supreme Court nominee, one option would be to change the Senate rules to get rid of that filibuster in like fashion to what's been done before. This table gives you a sense of the frequency with which presidential nominees are confirmed. So this is going back all the way to the Truman presidency. Most of them actually do get confirmed eventually. This is because if you're the president, it makes you look pretty bad when you make a Supreme Court nominee. It's the most important appointment you ever make. It looks bad it reflects badly on you if he or she doesn't get confirmed. So generally presidents consider the type of people that the Senate will be willing to actually approve of, and then choose from that basket of people rather than people that are going to have a really tough time and aren't that likely to be approved. In terms of, we've been talking a bit about filibusters. In terms of filibusters, the only Supreme Court nominee to ever be filibustered was Abe Fortas here. and this is actually after he was already appointed and approved by the Senate as an associate justice. He was then up for appointment as Chief Justice, but the Senate didn't approve of that because of a filibuster to prevent him from becoming Chief Justice. So he was already on the court, but then filibustered for basically the promotion that he was going to get. This chart, you'll note, for those of you who have been paying attention to politics over the last year, is a little bit out of date since Obama has now had a third Supreme Court nominee. So President Obama, following the passing of Antonin Scalia in February 2016, President Obama nominates Merrick Garland to fill his seat. This was a really big upheaval in the Senate, which is controlled by Republicans, since Scalia, he was one of the really most conservative justices on the court, and so he passes, and Obama, his nominee Garland, he, from all accounts, was either a more moderate or liberal justice than Scalia would have been. So, given the balance of the court, that really would have thrown things probably in favor toward more liberal and democratic leaning rulings going forward. So the Republicans, since they control the Senate, they just refuse to hold hearings or vote on Garland. So a few weeks from now, when incoming President Trump takes office, he will immediately have a Supreme Court seat to fill, and will probably have a relatively easy time of it, unless the Democrats, since they do have a filibuster-proof majority, attempt that. But again, if that occurs, the Republicans do have the recourse just to change the Senate rules again and get rid of the filibuster for Supreme Court nominees as well. So that's going to be an interesting thing to look out for in the early term of the incoming president. All right, so the last thing that we should talk about here in the lecture, we've talked now about what the court looks like, how it's comprised. Let's talk now about those judges that are sitting already on the bench. How do they go about making their decisions? Let's talk specifically about three different paradigms or models that they might use to inform their choices and their ultimate rulings. Really, the idealistic model is the legal model here. So this is saying that judges who preside over a case, when deciding on how to rule, they should be looking at the relevant law, deciphering how it relates to the facts of the case, look to see whether precedent exists for previous cases, look to see what the Constitution says, and basically use these factors to rule in an objective manner based strictly on the legal situation and the facts of the case. An important concept in the federal judiciary is known as stare decisis. This is the paradigm and the legal principle whereby judges are expected to obey existing precedent. So most often, when a case comes in front of a judge, if there's a similar case, the judge will look to what that ruling was and follow that precedent and rule in kind. This corresponds to the judicial philosophy that sometimes you'll hear when people are commenting on the judiciary in the media, judicial restraint. So this would be when judges basically just follow the law, they practice stare decisis, and really only overturn existing precedent. They only really rock the boat in cases where there's really a clear moral imperative, or they think that a past court has really screwed up and misinterpreted law or misinterpreted the Constitution in a really egregious manner. One historical example we've talked about back during, I believe, it was either the Constitution or Civil Liberties lecture. The court originally rules in favor of public segregation in Plessy v. Ferguson. Then you go forward about 60 years in Brown v. Board of Education, and they overrule their previous holding from a previous court. So this is a case where obviously they thought that the decision made in the prior case was so bad that it warranted overturning the existing precedent. In contrast to judicial restraint, Another term you'll hear about by judicial commentators or scholars is judicial activism. So this is kind of the opposite of restraint, whereby instead of just looking at the legal principles of the case and the facts of the case, judges also see that they have some leeway in deciding based on things like their own opinion, public opinion. They may have some desired outcome, in other words, that may be there for reasons other than just strict legal interpretations. So this is associated with what's known as the attitudinal model. This is a model that recognizes that these judges are people, and they're going to have their own existing political ideology. You can try to characterize them in terms of liberal or conservative, and generally the judges are going to try to impose their ideology in their case rulings. So, not necessarily so concerned with the legal or factual aspects of the case, but really just looking to rule in a manner that promotes their own personal ideological predispositions. And the final model we're going to talk about, the strategic model, can be seen as kind of a combination of the other two we've talked about so far, the legal and the attitudinal. We probably don't think of judges in every case as simply imposing their own policy views and ideologies in order to influence policy in one direction or another. On the other hand, we probably as well don't see them as always just looking at strict legal interpretations, the facts of the case, and precedent. It's probably in most cases going to be a mixture of the two when there's a significant case coming in front of the courts. So you have judges who have their own opinions and ideologies. However, they also recognize that part of what's important for the functioning of the courts is what we talked about earlier, legitimacy. They can't be seen as simply going there and ignoring the facts, ignoring legal principles, and just imposing their own will and own preferences in every ruling. And looking at now some practical examples, this is the composition of the court as it stands currently, except for Scalia, who passed away. So these 8 are in the court right now, and you can array them roughly in an ideological scale like this. So Ginsburg, Breyer, Sotomayor, and Kagan tend to be more liberal. Kennedy more in the center, as well as Roberts, and then Alito and Thomas, the two remaining really strong conservatives on the court. If you were to go ahead and try charting out their decisions like this graph does, so on the x-axis here is a measure of each justice's ideology, and this is a measure which is formed based on what the news reporting looked like prior to the Senate hearings and confirmation of each justice. So after the president nominates the justice, is the media saying they're conservative, liberal, moderate, what? And then that's scored and quantified and put on this scale. And then on the y-axis is the percentage of votes that are done in a conservative manner. So whatever is determined to be the more conservative ruling, does this particular justice rule in that favor, and the opposite, the more liberal choice. And you see that these two measures chart pretty closely to one another. The more liberal justices vote conservative less often than the more conservative justices up here. However, it's worth noting that even the most liberal justices don't vote in the liberal direction 100% of the time. As well, the conservative justices don't vote conservative 100% of the time. The y-axis here only spans from 40 to 70, so this sort of supports what we've been saying this whole time about legitimacy. These justices obviously have particular ideological bents, and it's reflected in their rulings. However, there are also a considerable amount of legal, constitutional implications that go into their ruling. Alright, that is the end of the lecture on the judiciary, and I'll see you guys next time.